You've got to get with an attorney to analyze the claims. You can't just go with your gut or with your emotions. Even inventors, will get a bit confused with what exactly they own. With the patent rights, it isn't the pictures, not the written description. It's the numbered set of claims. And those claims are word by word important in terms of their scope. And so having that look at if there is potential infringement, doing what's called a claim chart, and then presenting that if it does show infringement on each element, take it to a patent litigator and they can maybe move forward. So what can be done if a patent is rejected due to prior art, but the same invention was already patented in another country using different terminology? I thought this is fascinating, this concept of examiners aren't perfect and they don't always have all the information. And so this sent me down kind of a wild goose chase. Is if you're watching a competitor really close and you've got some intelligent IP attorney working with you, you can actually watch their publications, their applications that are pending. As they get published, you can help the examiner and help them find prior art. And so you can submit third party. It's called a pre-issuance submittal. And it's just providing information to the examiner, showing them, hey, there's already been done before. There's already been patented in another country. And so supplying information to the examiner while they're examining.
Sounds like a letter of protest on the trademark side.
Okay, that's what it's called over there, a protest. Okay, interesting. Yeah, it's sort of, and that's before that opposition period, right?
Correct. Yeah, it's before the examination. So if we see someone who's filed something similar to our client and we're worried that it's going to get through the USPTO process for whatever reason, you might opt to file a petition.
Yeah. Well, and it's important to kind of do these, especially on the patent side. I'm not sure if it's as bad on the trademark side, but after grant, crazy expensive. There's two ways. If you slip up and wait for their patent to get granted, you now only have 9 months.
Okay.
And to do a post-grant review. Oh my gosh, whoops. You didn't see this piece of prior art. Well, it's $25,000. That's the USPTO fee for a post-grant review. Yes. So it's a giant slip up. Usually large companies can really afford to kind of do this type of thing.
That's wild, JD. 25 grand?
25 grand. Yeah. So don't miss it. If you've got the ability to walk
for a re-examination?
Yeah, for inter partes review, an IPR is $23,750 for up to 20 claims. At PGR, which is a little different requirements, 25 grand.
Was it always that expensive, or is that pretty recent?
I just pulled it up because I was answering the question. I don't know if it's always been that pricey, but I imagine it's kind of maybe to combat, how many cases that tribunal is looking at. But I was blown away. So anyway, long answer to a short question of, make sure that examiner gets it well before it issues. Matt, on the trademark side, what can you do after registration?
So we can cancel. So we can still file a cancellation proceeding with the Trademark Trial Appeal Board. And really, for all intents and purposes, opposition occurs during the application process. Cancellation occurs after registration. They're the same thing. In my experience, they're basically identical in terms of the timing, when things are filed, the expense of it, that sort of thing. The case law. Yeah, it's really interesting. That's that expensive. That's wild. Because on the USPTO side, on the trademark side rather, it's still I think only $400 to do a reexamination.
Seems reasonable. Yeah, I guess on the term they're willing to admit that they're human. I mean, that's fascinating. And I'm able to do a little bit of homework and come back and do another session on that, kind of deep dive into those post-grant reviews.
Yeah, I honestly, this is something that's kind of on the newer side, on the trademark side as well. And I have not had opportunity to look at a couple of the new procedures that the USPTO has implemented in the last year. So that's something we can definitely take a look at. I would like to do that as well, because maybe in some cases it makes more sense to do a re-examination as opposed to a cancellation, but I'm not sure where that makes sense.
Yeah, cool. Can I sell a t-shirt with a city name that cites NFL team animals below it? The animal is AI generated and literally just the animal. It's not supposed to resemble the mascot or anything. It's simply just the animal. And then the establishment year of that team. So, for example, a t-shirt that says Chicago with an AI generated bear, established 1920. No logos, no team name. Same colors. May resemble NFL team colors.
Interesting. Yeah, so I think this is definitely both a trademark and a copyright issue. Okay. So I'll start with the copyright. So if you're kind of, essentially ripping off the look and feel of an NFL team's logo, basically adjusting their logo in such a way that you're probably violating their copyright, because they have the ability to change their logo in the future too within reason, right? And if you're kind of interfering with that, or you're making your own logo based on theirs, that could potentially be a copyright violation. But I think more easy for the NFL teams to pursue would be trademark infringement, right? You're using their colors, which are definitely registered at the USPTO. You're citing their city that they're in, or the state that they're in, and you're referencing like the animal or the mascot associated to it. Even though it's not the same, you're definitely playing right around the edges there of what's possible. In the other times that with other clients, I've said, hey, like if like we've had clients do like esports betting applications and mobile applications, stuff like that. And we've said, hey, like you can use like the first 3 letters of the state or the city, and like you can use their colors, right? But you start putting logos on helmets and stuff like that, we're gonna get in trouble. I think this is probably a little too close for comfort.
Yep.
You could certainly do it, but I don't think you're gonna find many attorneys who are gonna say that that's okay.
If I trademark Spooty Doo, does it also cover Spooty Doo Consulting? And if I trademark Consulted Spooty Doo, is it also protected? I'm talking about a US-based scenario.
Yeah, good question. I get this one a lot, right? So if you register Spooty Doo and you're in like class 35 for like business consulting services, yeah, you're protected for anything kind of related to that in the business consulting field, right? So business services, probably hiring, recruiting, consulting services. And you don't necessarily need to add words like consulting or consulted or because at the end of the day, those words are descriptive of the services you're providing. And what you're really registering is the word Spooty Doo. So, like, for example, if you were to try to register Spooty Doo Consulting at the USPTO, let's assume that the USPTO said yes.
Right.
They're going to cross off the word consulting because it's descriptive of the services you're providing. And you can't have the exclusive right to use the word consulting in the consulting field. So that word gets scratched off. So you can't force that word. So what I always tell clients is, like, do you want to be on your website or with your clients? Do you want to be known as like Spooty Doo, or do you want to be Spooty Doo Consulting? Right? Because you can be either one. Just pick one and be consistent with it.
Consistency. Okay. Got it.
For a lot of clients, like who are using like a coined term like Spooty Doo, which I have no idea what the hell that is. So it makes sense to put the word consulting behind it so that your clients have an idea of what it is that you do. Right.
Yeah. Love it. Yeah. So, no, that's awesome. Awesome answer. Who can help us sell or license an aircraft related patent? My father's patent expires in 5 years, and major companies aren't interested or are using the idea without credit. So maybe they're infringing. If you have experience or connections, please reach out. So they did commercializing patents. It's a game that we're Bold is just entering into. We've got a couple different experts doing that. I'm stepping in as well. There's two main facets, I should say, of post-grant patent side. There's proactive, where you go try to sell and pitch to sell your invention or license it and get someone else to take a risk on it. Or there's also enforcement, and that's identifying infringers. And I think that's what the second part of this question is asking, whether they're using it without credit or there's some infringement happening. And to look a little further there, that may be the way to go, especially if it's toward the end of its life. There may already be some damages there if it's truly being infringed. You've got to get with an attorney to analyze the claims. You can't just go with your gut or with your emotions. A lot of even inventors, will get a bit confused with what exactly they own. With the patent rights, it isn't the pictures, not the written description. It's the numbered set of claims. And those claims are word by word important in terms of their scope. And so having that look at if there is potential infringement, doing what's called a claim chart, and then presenting that if it does show infringement on each element, take it to a patent litigator, and they can maybe move forward and work with them, maybe find a way to settle, and you can have a win-win where you get a royalty or maybe a lump sum to avoid having to have a drag out trial and pay the attorneys all the money. You can find a way to monetize your father's invention. To me, that's kind of my hunch based on the limited information I have here, but please do reach out. We'd be happy to help you. We would help get this moved forward. And I know that's different than trademarks, right? Trademarks is kind of the whole company, right? I mean, have you seen aspects of trademarks get licensed apart from all-out sale, or is it?
Yeah, certainly license aspects of the trademark, and that's one of the main reasons why at our firm we choose specifically to file trademarks separately as opposed to multiple class applications. There's some good reasons to do that, but licensing is one of those reasons. You can very easily just peel off one of the registrations, one class, and make that your license.
Oh, that's cool. Actually, I hadn't thought about that. So you got 5 different classes: apparel, consulting,
I have a lot of clients who have,
design. Yeah.
like working with a coffee franchise or yesterday, and they're going to be in 6 different classes, which is pretty standard for that field. It's a lot for a franchise, but yeah, I think at the end of the day, it makes sense.